My name is Martin Elliott, and more than a decade ago now, I was lucky enough to be appointed Professor of Physics here at Gresham College. It was scary enough giving lectures to the real public rather than my peers, but it was really tricky to meet all the other professors in the academic board, incredibly scary. And amongst them was someone whose wisdom, energy, passion and commitment genuinely changed my life, and that person was tonight's speaker, Sir Geoffrey Nice. Sir Geoffrey Nice was Professor of Law at that time, and his lectures were remarkable for their concision and for the challenge they laid before you as an audience and to governments at the time. His lectures are available online on our website and in the summary in his book, Justice for All and How to Achieve It. He's devoted his career to human rights and their legal maintenance wherever in the world they've been challenged. After practicing as a barrister from 1971 and as a judge in the UK, he worked for the International Criminal Tribunal for the former Yugoslavia, and he's well known for leading the prosecution of Slobodan Milosevic. But he also was involved in cases before the International Criminal Court all over the world in Sudan, Kenya, Libya, and victims groups from Iran, Myanmar, and North Korea. His wide knowledge leads him regularly to be a pundit on the international media, and some of you will have heard him on Today or seen him on CNN recently. Now, I had the privilege of working directly with Sir Geoffrey as a member of the China Tribunal, which he'll mention tonight, where we were addressing charges of forced organ harvesting, apparently being undertaken in the detention camps in China. It was a genuinely emotional experience, hearing gruesome evidence in person and analysing, frankly, awful data emerging from various routes out of China. We debated, we worried, we analysed, and we were horrified. And Sir Geoffrey kept us all in line, sometimes, I have to say, with a firm hand. Taught us important points of law, was scrupulously fair to all parties, and typically, for those of you who know him, worked tirelessly. We became judges under his tutelage. Now, the world is self-evidently in a bad place at present, with authoritarian, often plutocratic leaders pushing to expand both their influence and territory, usually by suppressing human rights in one way or another, or by initiating war. The Geneva Academy reports that currently there are over 110 armed conflicts taking place in the world. Now, Ernest Hemingway wrote in 1946 that never think that war, no matter how necessary nor how justified, is not a crime. It is always a crime. And terrible war crimes continue to be committed these days, literally before our eyes. And it's all too easy to turn one's cheek and say, well, that's nothing to do with us, there's nothing we can do about it. But tonight, Sir Geoffrey will use his decades of experience to address the rule of the law in war, and whether there's any hope of bringing its criminals to some form of justice, and whether indeed legal processes can do anything to protect us from future wars. Now today, although he's banned me from saying this, is Geoffrey's 80th birthday, and I'm not going to make you sing, but please do give him the extra loud welcome that he deserves, Sir Geoffrey Nice.
Thank you all for coming. We must deal with the law because it would be quite unwise of me to assume you all know enough of the law to understand the few things that I'm going to say, but I should make it quite plain at the beginning that what I'm going to provide you with tonight are probably somewhat unconnected topics. But we're used to having unconnected topics on war and law, especially since 22 and the beginning of the last two serious wars with which we are all aware. And you may find a linking thread between all of them. You may not. It's not for me to impose one. But they're a bit of a miscellany. Any case, what about the law? Well, I could give you the 2-minute summary of the law, but it's going to be a bit longer than that, because to save time, I want to weave in things about genocide and also about the United States of America. And at the end of the things I have to say, you may come to the unhappy conclusion that we are now in a time where there is limited effectiveness in the international humanitarian law, the law of war. And you may wonder if the time has come when we now need to consider whether we have a duty through our parliamentary system to make it perhaps better than it is at present. Our own government, of course, would never want us to think that we had any part to play in such an important topic. They only want our votes, and thereafter they would rather run things the way they do. So international humanitarian law starts with the creation of the Red Cross and the Geneva Conventions and the Hague Conventions in the last part of the 19th century. That law was about civilians and about prisoners and about weapons that you can use in war, and it may have had some effect on the conduct of the First World War. But there was no war crimes tribunal following the First World War, despite the fact that in the 1990 Versailles Peace Agreement, it was planned that the terrible Wilhelm was going to be tried. And unfortunately, he managed to hop it to the Netherlands, and they gave him sanctuary. So there were no war crimes trials of substance, apart from a very small number, after World War I. And before we leave World War I, and for a reason that will become apparent, I have to deal with one of the horrible events that happened in that war. We need to deal with Armenia. Armenia was a terrible massacre by the people called the Young Turks, who were in charge in Turkey, of the Christian Armenians. They were driven out of their country, butchered, massacred, and the total numbers of people killed was, I think, somewhere between 660,000 and 1.2 million. They were killed simply because of who they were and because they were Christians. And so, they were driven out, for those of you who've got good geography, to places like Saudi Arabia, Iraq, Syria, and so on. Interestingly, in the course of what was going on, and you want to bear this in mind when we look at genocide a bit later, tens of thousands of Armenian children were taken from their families and forced to convert to Islam, something we see reflected one religion to another to this very day. Now, coming up are a few names and pictures. Let me see if it works. It does. Of people who, not knowing at the time, and you're probably not knowing even now, have in their own way affected the way we all think. This is Pasha Talat Pasha, the title, and he was responsible in large part for the massacre of the Armenians. He said, and he's got two other people who are really important. The chap on the left is the humane, decent, concerned American ambassador, Henry Morgenthau, who knew all about the driving out of the Armenians and the massacre of them and wanted to do something about it. The chap on the right, Robert Lansing, was the United States Secretary of State for nearly all of World War I. And Morgenthau was so troubled, he spoke to the wretched Talat about the massacre, and Talat said, "Why are you so interested in the Armenians? You're a Jew. These people are Christians. What have you to complain of?" Mental responses of a kind that we may see reflected in other settings, even today. So Morgenthau pressed Lansing to do something, which meant America doing something in somebody else's territory. And one of the problems was that Lansing believed more than anything else in sovereignty, the absolute right of a country to do within its own borders what it wished. So he justified doing nothing and not saving how many of those 100,000 Armenians by saying this. He said, pretty unconvincing, by the way, "I could see that the Armenians' well-known disloyalty to the Ottoman government and the fact that the territory in which they inhabited was within the zone of military operations constituted grounds more or less justifiable for compelling them to depart their homes." 1914, ethnic cleansing approved by America. When the war was over, Talat fled to Berlin and avoided, therefore, the consequences of the trial in absentia that was performed by the successor government, in which he was sentenced to death. So he went to Berlin because Germany would not extradite to Turkey. He had some bodyguards with him, but sometimes life doesn't work out as you expect, because in 1921, this chap, Soghomon Tehlirian, something of an Armenian activist, was also in Berlin, and he had a gun. And he tracked Talat down, called him out by name. Talat turned, bang, dead. Tehlirian waited to be arrested, waited for a trial that took 2 days, a jury's verdict of not guilty, I'm happy to say, which lasted 1 hour, and that was that. Except that it wasn't, because the trial was the subject of information around the world by newspapers, including to Lviv, where a young student of philology by the name of Raphael Lemkin couldn't understand how there was no process for bringing justice to a man who had done such damage in the hundred thousands at least. So he gave up philology and converted to law, became a prosecutor, and became obsessed with this concern of his. Conferences all over the place, teaching at universities. The Second World War eventually approached, and Lemkin, a Jew, escaped to America, although 49 members of his family perished in the Holocaust. When the war ended, Lemkin had, by the time the war ended, year before, Lemkin had written a book. And it was that book in which the term genocide was first used. That's the history of it. Lansing, Talat, Tehlirian, the trial, concern, the book. That's why these people are insignificant in our lives, little though we knew it. So, with the war over, Lemkin came back to Nuremberg, where, as we know, I expect all of us, the Nuremberg trials were to be held. By the way, the picture shows Tehlirian on the left, and there he is being tried on the right. And here is a picture of Raphael Lemkin. There are no pictures of him as a younger man. That's all you can get. And here is one of the many well-known pictures of the trials of the Nazi leadership at Nuremberg. So, what else should we have in mind at this time? Well, in 1945, here in London, there was a conference. It had been decided in the middle of the war that the Nazi leaders would be put on trial for breaches of the law, for war crimes. But they didn't actually have a statute, so they had to decide what the law was. And at the London conference, I suppose the lead person was probably Justice Jackson, the senior American prosecutor, a Supreme Court judge on secondment, effectively. And it's really important to understand his approach then to the law. He was determined that there should be no crime that simply concerned the annihilation, the destruction, the killing of the Jews. They could only feature in an alleged crime if the killing of them was part of another regular war crime. He explained it in different ways. Let's see what he had to say for himself. First of all, this is how it looked in the indictment. So you refer to murder, extermination, and enslavement, but it's only in execution of the plan for preparing and prosecuting aggressive or illegal wars. It's the war crime that carries the annihilation, nothing else. This is Jackson. He says the internal affairs of another government are not ordinarily our business. That is to say, the way Germany treats its inhabitants or any other country treats its inhabitants is not our affair, any more than it is the affair of some other government to interpose itself in our problems. It was the part of a plan for making an illegal war. Unless we have a war connection for reaching them, the atrocities against the Jews, then I think we have no basis for dealing with them. Why did he think this, apart from general sovereignty belief? He explained himself a bit more. We have some regrettable circumstances at times in our own country in which minorities are unfairly treated. Lynching of black Americans carried on until 1950. Only because the concentration camps and the deportations were in pursuance of a common plan or enterprise of making an unjust or illegal war in which we became involved, we can see no other basis on which we are justified in reaching the atrocities which were committed inside Germany, under German law, or even in violation of German law by the authorities of the German state. Lemkin, at the trials, was successful in having his term used as an adjective or a noun, but he realized that the law meant you could have a new genocide happening in the next door country, and there would be no legal justification in going in and stopping it. Just as Lansing had declined, or the president had declined, to allow people to go into Armenia, or rather Turkey, and stop the Armenians being massacred. Realizing this, Lemkin gave up his job, lobbied the newly formed UN, which came out of the League of Nations in 1946, then went to New York and single-handedly, pretty well, had the Genocide Convention passed. He died about 10 years later, a pauper, with just a few people at his graveside. Thus the end of a man who developed and changed the way we all thought. Now, after Nuremberg, there wasn't much need for trials because the Cold War froze everything. And so the first time you see war crimes trials are Rwanda, 94, and the Yugoslavia tribunals, which were pretty well ad hoc tribunals set up by the UN, probably out of a sense of guilt. Then in 2002, the Permanent International Criminal Court came into being. Now this, in the newly fashionable proper projections of the globe onto a flat surface, shows the countries that are signed up as states parties to the International Criminal Court. It's only the countries in green. None of the other countries. Different reasons for their colors, don't worry. Just the colors in green. America, Russia, China, India, Pakistan. Not interested, thanks very much. This is an indulgence. Do you mind an indulgence? That's how big Africa is. Did you know that? It's enough to take all of the United States except Alaska, all of China, all of India, most of Europe, except for England, which has got to fit into Madagascar, and Eastern Europe. It's perhaps worth thinking about when we consider the composition of this court again. But that was a diversion. Let me now come to the last part of this thread, if it is a thread. President J. Donald Trump. Now, in his first term of office, in September 2018, when he'd just withdrawn from the United Nations Human Rights Council, he said this, and it's actually worth following his words, whoever wrote them for him, quite carefully. Second paragraph. The United States will provide no support and recognition to the International Criminal Court. As far as America is concerned, the International Criminal Court has no jurisdiction, no legitimacy, and no authority. New paragraph. We will never surrender America's sovereignty to an unelected, unaccountable global bureaucracy, the United Nations, I guess. America is governed by Americans. We reject the ideology of globalism, and we embrace the doctrine of patriotism. Nobody knew what he meant by patriotism. On the occasion of his more recent speech to the UN a couple of weeks ago, his office really clarified it. What he meant by patriotism was indeed sovereignty. That's the word he should have used. Around the world, responsible nations must defend against threats to sovereignty, not just from global governments, but also from new forms of coercion and domination. He is explicitly rejecting the validity of an international court of any kind, as well as saying pretty negative things about the United Nations generally. And that chimes completely with Lansing 120 years before, with Jackson 1945. And I'm afraid it leads to this somber conclusion. There is no way America is ever going to be part of an international criminal court, nor Russia, nor China, nor India. It's of no interest to them to have their homework, as it were, when engaged in fighting, marked by countries they regard as inferior. Why should they? Probably if we were in their position, we wouldn't either. And it goes actually now, in the case of Trump, further. Because his disregard for international law is complete. Although I'm not sure we've seen all 20 points of the present 20-point plan, for Israel Gaza, I have heard it said that there will be amnesty for all leaders. No one will be put on trial. And indeed, as we know, Trump's also trying to get Netanyahu off his local criminal cases. Does this mean that with so many big countries taking no part in international criminal law, we should all despair? Because that, I think, now is a reality. But happily, not quite despair. There is some optimism to come. But first of all, a couple of short passages, keeping an eye on the clock. And first, about genocide itself and the way it was defined in the Genocide Convention, which is adopted by all other courts all around the world. And so I only really want you to look at one part of this document. I've given a reference in the reading list to the whole document. So the convention, which came into force in 1951, says this under Article 1. It's worth really reading. The contracting parties, those who signed up, confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law, which they undertake to prevent and to punish. The world's most senior court, the International Court of Justice, has held that undertake means undertake now to stop genocide. Not tomorrow, not the day after, now. Why? Did they understand that which scholarship has shown since, that genocides never stop themselves, or almost never stop themselves? They have to be stopped by external force. They're not unlike, to use a silly example I've used to try and persuade our hopeless governments sometimes how they should see things. They're a bit like this. If you walk down a street, there's an open door, and there's a man hitting a woman over the head with a house brick. What do? Stop and wonder whether you should do it, or, as we'll come to this, see if there's a judge who can tell you whether you should go in. No! You take action immediately. And that's what the draftspeople of this convention clearly understood and wished to be the rule of law for the future. The rest of the definition is worth quickly noting. Acts committed with intent to destroy in whole or part a national, ethnic, racial, or religious group as such. And then there are 5 ways in which you can do that to become a criminal: killing, causing serious bodily harm, imposing conditions of life calculated to bring about the destruction of a group. And then these: imposing measures intended to prevent births within the group, forcibly transferring children of the group to another group. Note, if you look at the whole document, there is not one word in it that says governments can, should, must make their decision only when a judge says genocide is being committed. Not at all. And indeed, the time interval between seeing something that might be genocide and getting a judge to decide would make it impossible to do it with the immediacy that the court has said has to follow. That is a point of enormous importance in the failure of all governments, not just our own, to deal with genocide in the way that people really want it. And so I turn to the question of genocide recognition by states, and in particular to how the United Kingdom has let the world down, because the United Kingdom has used as an excuse for not doing something where genocide may be occurring, oh, we need a judge to decide that first. Oh, there's no judge. So we don't have to do anything. That's the truth of our governments. Not just this one, the last one and the one before and so on, all of them. And what's more, it's probably the same around the world, because No state, as far as I know, has ever made a declaration of genocide under the undertaking of the convention and then taken action following that pronouncement of genocide. And the United Kingdom and the United States also found another clever way of dodging their responsibility in 1994, when the Rwanda massacre, already described as a genocide, was taking place, and when they were all on the ground there and all decided to withdraw. They were able to withdraw because on both sides of the Atlantic, and in the reading list you'll find completely persuasive, more than that, it's unbreakable evidence relating to both America and Britain. What happened was the politicians got legal advice. Use the word genocide, you'll have to do something. So the politicians, in our case, the then Foreign Secretary, thumped the table. Never use the word genocide and we won't have to act. They pulled out, what was it, 800,000 Tutsis were butchered. How many might have been saved had the duty to act been responded to? Well, racing ahead a bit, this approach by our government has led to my wasting my time writing letters in respect of determinations made by tribunals. I've been sitting on one of them with Martin, writing, do you accept the results of what we found, in particular in one, do you accept the response that we have found about, in respect of the Uyghurs, this was of China, about genocide? And all you get back from the government is something like this, from the Right Honourable Anne-Marie Tehlirian. She praises us for our work and says, it remains the policy of the British that any determination of genocide is a matter for a competent court or tribunal, rather than for governments or non-judicial bodies. Our long-standing position on this matter is fully consistent with our obligations under the Genocide Convention. No, it isn't. And the Rome Statute. No, it isn't. But that's been the attitude of government. Ha-ha. The UK got itself caught out quite recently. There's a case going ahead where a pressure group is trying to say that the government should not allow licenses for spare parts for F-35 bombers because those spare parts might be used to commit crimes in Israel. Now, the government's defense to that may well be perfectly valid. Sorry, this is such a big overall provision of spare parts for F-35 bombers as part of an overall defense plan. We can't pick them out. So its defense may be perfectly satisfactory. We don't know. The case is still being retried or tried or on appeal. However, in dealing, in writing, in witness statements, and then in a letter to a select committee, the then Foreign Secretary, David Lammy, had to deal with the obligations under the Genocide Convention. And so shall we see what he said? In a letter, he said, as per the genocide, the crime of convention, the crime of genocide occurs only where there is specific intent to destroy and hold apart a national, ethnic, racial, or religious. Correct. Well done. The government has not concluded that Israel is acting with that intent. Snookered. You can't decide that something required to prove a crime has not been proved without having conducted an investigation whether it is proved. And so all those of us who've assumed that within the Foreign Office or the Cabinet Office teams of people have been assessing genocides and other crimes committed by other states where relevant to our own security, kept the reports within and never told anybody what they found. Not true. Of course they did. It was obvious they did. And gave the game away. Can we see the reasoning of his decision? Secret. Should we be allowed to see the decision, the reasoning? In these troubled times where people talk of nuclear wars and even of Armageddon? I think so. Right, at speed, a little bit of optimism. Don't overlook the fact that all the courts that have been in existence, most of the ad hoc ones, have ended their work, but the ICC is still around, have tried and convicted lots of people. Yugoslav Tribunal 93, Rwanda 8 of the genocide there, and Sierra Leone, Cambodia, and the International Criminal Court itself. Most recently, a couple of weeks ago, in respect of, I've forgotten his name, but very serious crimes committed in Africa. The law's been developed by these courts over the years, right back to 2012, in the case of a chap called Lubanga. And the ICC picked up where the Yugoslav Tribunal failed and dealt with crimes of sexual violence against women, which has always been underdone. And in a very important case, which you can see called Ongwen, when you get a copy of the printed version or look it up online, a case called Ongwen made many determinations that are in favor of and assisting women in exerting their proper rights in matters of this sort. So a substantial move forward. Also, you had innovative lawyering that says where you've got a state here that is a state's party to the ICC and an adjacent state that isn't, crimes committed in the adjacent state may sometimes continue across the boundary into the state that is a state's party, and therefore you can make the violating state culpable. And that's what happened in a very clever bit of lawyering concerning what was happening in Myanmar, Burma. And once that sort of case is initiated, do you know what? The USA, Russia, and China, they can't do anything about it. It's out of their hands. And I've got two things to get through before a few conclusions, and one is a dream. It's always a good idea to be able to dream and to be idealistic. And this dream comes from an event in which I had a personal involvement of the slightest kind. It's about Israel, Gaza, but I express no views on the merits, of course, neither now nor in questions and answers. In 2014, there was one of a series of conflicts between Israel and Gaza called Operation Protective Edge. It lasted about 7 weeks, 2,000 Palestinians killed, 500 of them children, about 100 Israelis killed. And when it was over, the Palestinian Authority, dealing of course with the West Bank and Gaza, wanted the ICC to investigate. I happened to know this at the time, but I think it was well known to the ICC because I happened to be in Gaza and I interviewed the then Prime Minister of Gaza, a man called Ismail Haniyeh, now assassinated, and he told me about this. And I said, but do you understand that if you have an investigation, you get investigated as well? He said, yes, of course. And in the following year, in a process that's very long and complicated if you do it strictly according to all the rules, especially with a body like Hamas and the Palestinian Authority that don't have full capacity at the United Nations, it's going to take a very long time. So the prosecutor started an investigation in early 2015, And one way or another, the final decisions were only made in 2019 and 2021 when she opened a full investigation. Fatou Bensouda is her name, and she's now the Gambia's High Commissioner to our country. Think about it. Crimes require intention. In 2015, what do we know of the stated intention of Hamas? That they wanted to be investigated. Do you, if you are being investigated and want to cooperate, do you do the worst things? Probably not. It's in your interest to behave well because you want a result. What happened, information again in detail in the reading list, is that America opposed an investigation come what may. Fatou Bensouda and her family were subject to the most dreadful threats to life, not to investigate. What would you do if you had supervision of two standing combatants in a dispute? Alleged bully, alleged victim at a school. Two people in your employ who can't sort something out but are absolutely at it. Two people who might be advised to go to an ordinary court. And one of them says, for goodness sake, I really want this to be resolved. And there's the person who can be the arbitrator or the decision maker. What do you do? Say, go to hell? Or do you say, fantastic, we must encourage that? Because that's likely to be a better answer than letting you two fight it out. Did any country encourage the investigation? No, not one. Supposing they had, yes, I'm an idealist in this, no doubt politicians would mock me for thinking it, but just supposing countries had given full support to an investigation, persuaded Israel that they too had to be willing. Might Hamas's intention from arguably good to ultimately wicked evil in October 23 have not got that far? Might October 23 and everything that has followed never have happened? Will our governments ever think radically? It is the investigation that stops people doing bad things, not past convictions of war criminals. It's investigation. It's that an opportunity that was lost through lack of vision. The second thing I want to deal with is people's tribunals. You may think there's no thread that connects them to anything else. Maybe there is, maybe there isn't. But I'm going to talk about them in any case, because I was involved in 4. And they taught me a lot. The first was the Iran Tribunal, which I started being. I was asked to be on the advisory committee or something. I thought it was a pretty hopeless cause and wasn't enthusiastic and gave legal advice which was always rejected sensibly by the diaspora who were running it. A brilliant Iranian diaspora member called Babak Imad. The trouble was the Ayatollah's regime of the 1980s. And slowly I began to see there was something in this. And indeed, in the second part, there was a part of proceedings in London. In the second part of the proceedings, I took part and called some witnesses, one of whom remains with me as a most inspiring person I've ever met in many ways, for how she dealt with 9 years or something of captivity by the Ayatollah's regime. When the judgment in the Hague was given, in this very beautiful room in the conference centre there, and these are lots and lots of members of the diaspora, and the judgment was given by the judges who were presided over by a retired, very respected judge of South Africa's top court. And the judges were also experts in law and academics and all sorts of people like that. when the judgment was given, the people in the hall made me realize that one of the great values of judicial international process is that people have their suffering and have the suffering of those who are dead reflected in a public pronouncement. It was one of the real benefits. There was another. The second tribunal I was engaged in, I won't name now, it was material in the reading list, and I won't name it because I'm afraid it made quite a lot of mistakes. But the people were terrific. I mean, they were well-intentioned, knowledgeable, concerned, committed, but they sort of got it wrong. And so they asked me if I'd be a judge, and I said, well, no. Can I not just advise you on the background on procedure? Be a judge? No. Be a judge. So I gave in. And although the procedure was pretty hopeless, and I'm happy to say the tribunal actually did have good outcome, I learned something from being a judge. Again, presided over by a very senior judge from South Africa, retired. But the other judges were committed human rights specialists, lawyers, journalists with great background in the subject. Hopeless. They couldn't do the job. Once the door was closed, they argued the case. They did not assess the evidence and reach factual conclusions, apply the law, and have a satisfactory result that could be valuable, because people's tribunals are pretty presumptuous things, aren't they? A bunch of people dealing with major issues. You've got to get it absolutely right. And the best way of getting it right is to have clear factual determinations that can be shown to be reliable, evidence-based, and that's it. The law at the most conservative, nothing more. So I learned something. I thought that might turn up useful one day. And the third tribunal was the China Tribunal, about which Martin has referred. Now, that came about because Ben Rogers, he was going to be here. Is he here? No, he doesn't seem to have turned up. From Christian Solidarity Worldwide, asked me to write an opinion on whether this killing of people, Falun Gong practitioners mostly, to order, cutting open their bodies, ripping out their organs, and using them in China's PRC, People's Republic of China, forgive me just saying China for the purposes of brevity. He said, would I write an opinion on whether crimes have been committed? I said, well, that'd be a bit of a waste of time. Nobody bothered to read it. They certainly wouldn't do anything as a result of it, and it'd be lucky to find itself as an op-ed in a small regional newspaper. Had those people who'd asked him to make this request, a non-governmental organization called ETAC, based on the other side of the globe, had they considered a people's tribunal? To which the answer was no, and they don't like the idea, and I could completely understand why. Why would you want to have a bunch of complete newcomers deal with an issue about which you were completely satisfied? Because the people who ran ETAC, some of them were Falun Gong practitioners, but many were high-level academics and lawyers from Australia and Canada. Why would you want to take the risk that a whole new bunch might find a contrary conclusion? I went there with Hamid Savi, the man who ran the Iran tribunal, and we tried to show them how it could be done. Not interested. Eventually, they came back and asked if I would form a tribunal, because, as so often with civil society, NGOs and so on, you can't cut through to government. You might get your evidence approved in parliaments, in committees, but getting government to act, no. Maybe they thought, well, just possible that a tribunal would have more effect. Even then, we didn't entirely agree, the NGO and I. They wanted big names of judges. I was perfectly happy for that to happen, and Hamid and I went round and contacted everybody we could find, see if there was anyone who would do the job. But at that time, China was everybody's best friend. And so, you know, all these people, Mary Robinson and so on, to whom we wrote, said, sorry, busy or not interested. So eventually we formed the tribunal, and even then I had trouble imparting such sense as may have come from my experience. I said, oh, by the way, we're still looking for at least one more person. There's a businessman I happen to know from civil society work, known to be an ethical businessman. How about him? Oh, no, a businessman on a human rights activity? Good gracious, no. But eventually they succumbed. And it was interesting in our discussions in that tribunal that we had 2 hearing sessions separated by several weeks. And at the end of the first, we were just closing our papers, prepared to go home. And it was the businessman who said, look, we have already reached a firm conclusion on something. And this is a tribunal that is concerned with saving lives by perhaps stopping people being killed for their organs. Shouldn't we say as much? Lots of sucking of teeth by the rest of us. But yes, he was right. We made that public pronouncement, and it's always been regarded as one of the most important things that tribunal did, because it showed the purpose of the tribunal and its ability to change events. In that tribunal, it emerged that Uyghurs, whom I expect you all remember something, the Muslims living in northwest China's Xinjiang province, had also been used for forced organ harvesting. And we found that some of them had been used, or we heard evidence some of them had been used. And so the World Uyghur Congress approached us to set up a new tribunal. And this tribunal was set up in exactly the way I'd hoped, so that we had people, and there are 3 or 4 of them here tonight, and one indeed from the China tribunal, who we were able to select from a pool who had no interest, prior interest in the topic. They weren't human rights specialists, none of that stuff. They were people high up in their own professions who had one thing of value: integrity. And they demonstrated throughout the hearings. You don't know their names, do you? These people work for nothing, not only not for money, for nothing else, no recognition, just to get a job done. And it was me, Hamid as counsel to the tribunal, and the businessman, his name is Nick Verch, as the vice chair. And it worked really extremely well. And at the end of it, we made a determination of various terrible crimes committed against the Uyghurs, including one form of genocide, interfering with births. And it was interesting, by now China was everybody's worst friend or non-friend. And so there were lots of other bodies around the world saying, oh, every form of genocide has been committed, and expand the law, do what you can to punish China. We said, no, we can only find the one. We'll apply the most conservative law, and that will mean, we hope, a judgment of security. And that's actually what's happened. In both cases, this, by the way, is the China tribunal judgment, all the evidence, all the argument. I wonder if Anne-Marie Trevelyan read it. There's a similar one for the Uyghur Tribunal. These tribunals can serve, they're not panaceas, they're not good for all purposes, but they can serve a very important function. So far as the NGOs who commission them, they provide back to the NGO a tool, or if you like, almost a weapon, that can then be used by the NGOs in their continuing work. Very much what has happened in the Uyghur Tribunal judgment, and also with the China Tribunal judgment, which, as Martin would be able to confirm, has been effective not just in governments around the world in creating legislation and so on, but also with professional bodies, which might have been over-tolerant, transplant bodies, which might have, transplant surgeon bodies, which might have been rather tolerant of China practices which needed to be called in. I suppose so far as war is concerned, it's wherever Russia, the United States, or China choose to take us, or to allow war to happen. And if wars come, more wars, the threat of accountability may achieve Very little, because there may be no after-the-event accountability, none to make war crimes perpetrators afraid. But what of the law itself and its apparent ineffectiveness? Humanitarian law will not actually disappear. And the major institutions, the International Court of Justice and the International Criminal Court, should survive. Their law will likely be the law of many parts of the world, because law can rarely be far out of step with what the public, us, believes to be right. And the world's public has been getting acquainted in the last 2.5, 3 years with quite a lot about law and war, and there's no suggestion that the public wants other than the law to be effective. The international law will be applied in domestic courts, as it has been on many occasions already. But will resolution of Israel-Gaza and Russia-Ukraine with amnesty, without war crimes, trials or similar, return us to a 19th century pre-Geneva Convention world without conflict resolution as a possibility? It does look just about possible, especially if you see that thread of thinking of the United States of America. So, I was fortunate, wasn't I, to change career 27 years ago and find myself working within and beside national and international systems and organizations that believed a safer world would come from having and applying an international rule of law. I was less fortunate in living in a time when the political authority of the United Nations can be disregarded because its institutions, the Security Council in particular, which can stop cases going to the ICC if one of the veto-holding members so decides, need reform. UN needs reform, which may never come about. And of course, it's very unfortunate if we're in a world with no post-conflict accountability. At the national level, it was not entertaining or amusing for me when my immensely talented tribunal colleagues, Martin and those from the Uyghur Tribunal, Shadi Sadir at the back and others, had their work, backed by their integrity, set aside as not worthy of proper consideration by government, who could certainly do no better than we did. It was disappointing to find this being done by politicians who have been a disappointment to us all. Of course you need to have someone else buy you your suit if it needs to have a specially large pocket for a rabbit-sized envelope. The other side may be even worse. Grim times? Possibly. So what should I do? Write another letter to the Prime Minister or the Foreign Secretary in light of David Lammy's confession, trying to find out what they actually thought about the China Tribunal, the Uyghurs, and all the other allegations of genocide and grave crimes around the world? Or perhaps just go out into the garden and wait for the very bright light in the shape of a mushroom coming over a distant horizon. Probably I should do the former. This is Ben Ferencz. He died aged 103 in 2023. He was the last Nuremberg prosecutor. He prosecuted a huge trial when only in his mid-20s, the Einsatzgruppen trial at Nuremberg. He was only 5 foot tall. You can see they didn't even give him a step up. Perhaps he didn't ask for one. After doing that trial, Ben Ferencz spent a great deal of his working life right until he died, advocating for international law, for the creation of an international court, and to replace the rule of force with the rule of law. He had a motto, which he always used when he spoke to the young, or even the younger. Never give up. And in light of the age difference between him and me, I think I'll do as he said.